it's going to be a very timely discussion. We have a major new legislative changes coming in the European sphere on the digital rights and workplaces. So without further ado, we can look more to the EU's new Artificial Intelligence Act. And the new Artificial Intelligence Act, it's been agreed on political level already, that we do know, and the finalized technical process is actually being negotiated literally as we speak. And the new regulation will be a globally unique and groundbreaking initiative that tries to tame the Wild West that AI has been, and in the same time ensure that the fundamental rights are respected from EU workplaces to all the civil rights. And the first presentation will be provided by Paula Goertler from the Center of European Policy Studies, and she will be providing us with an overview of the AI Act and the process, how we got here, and what is actually the main content of the new regulation. And well, as trade unions, we are focusing specifically, of course, on the workplace dimension of the artificial intelligence. And the trade union movement has been raising numerous concerns about the workplace coverage of the AI Act. A number of AI systems which will not be regulated by the AI Act are actually already in place in the European workplace, which means that the new regulation will leave potential loopholes that may harm workers' rights. And the EU member states need to have, of course, an ambitious approach when implementing the AI Act in their national level to ensure that also this workplace dimension will be properly covered. And with the new Platform Work Directive, it is still unclear how EU should complement the new regulations, both of them with additional legislation to address specifically the algorithmic management aspects. So the workplace impact will be presented by Kate Munkrium from AC Denmark, our colleague who is a specialist on digital affairs, and that presentation will be specifically looking on the AI Act and what is its impact on the workplaces themselves. And finally, of course, AI Act, it's not going to be operating in a vacuum. There is a lot of international standards being developed, and trade unions and human rights advocates need to be able to address both AI systems and AI regulations. And this comes all the way from the national levels to individual companies. And for this, we do need tools. And these tools are provided by, for example, academics and civil society experts in projects such as AEQUITAS, which is a EU Commission-funded project that is specifically providing tools for detecting and fixing unfairness and bias on AI systems. So our third presentation will focus on the AEQUITAS project, and it will be presented by Maria Rebrean from Ally, which is a Dutch organization specialized on artificial intelligence. And then, without further ado, I think we can kick off and start off with an overview of the AI Act, and this will be done by Paula Goertler's presentation, which is going to be a reflection of the recently leaked 1,000-page negotiation file on the AI Act. So luckily, I think you don't have to read the whole file, but rather listen what Paula has to say on this topic. So Paula, without further ado, the floor is yours.
Thank you very much also for the great introduction to this whole webinar and placing the presentation. For clarity's sake, I have not read the 1,000 pages of the 4-column document that has been leaked on Monday. 24 hours is too little for me, so please do feel free to look through the documents yourself. I have focused specifically on the AI Act and workplaces, just to stick with the topic of this webinar. And a minute ago, this was still working. So let's hope that I can still share my slides and that you see the full screen.
Yes, they are well visible.
Great, perfect. So yes, my name is Paula Goertler. I work at the Center for European Policy Studies in the Unit of Global Governance, Regulation, Innovation, and Digital Economy. For short, it's called GRID. It's headed by Andrea Renda. As you know, you might know him because he has been quite public as well on the matter of defining the AI Act. Speaking of defining, I wanted to start out with defining AI systems just to make sure that we have the same vocabulary. And some of you might be aware of how difficult just finding a definition of AI systems has been in the process. I feel like every twist and turn of the regulation was highly debated, either for political reasons or because the technicalities are just so complex. And defining AI was difficult because you don't want to be too broad. You don't want all data analysis. to be captured. You don't want software, for example, Excel should not be counted as an AI system, or most of its functionalities, at least as I'm aware. But on the other hand, you also don't want to be overly narrow in defining AI, because that means that you lack future-proofness. The final result has been a definition that is aligned with the OECD. And this is the definition that is now in the provisional agreement. There it is. Just to highlight a few aspects, an AI system is a machine-based system. It has a certain level of autonomy. It shows adaptiveness after deployment, so it continues to learn. It infers from input to generate output that ultimately influences physical or virtual environments. With this short definition at the start, let me tell you a bit more about what you can expect from this presentation. I will briefly present the AI Act, the timeline of the drafting of the regulation up to today, and a bit into the future as well, and the general approach that has remained largely the same from the Commission's proposal in April 2021. I will actually skip over the trilogue positions because, as you've heard, we have the provisional agreement now. I have focused very much on what does the provisional agreement include on AI systems in workplace environment. And based on that, then I've looked closely at the requirements, obligations of high-risk AI systems, and I will close with the timeline for implementation. Now, the AI Act in brief, I would say it all started in April 2021 when the European Commission presented its proposal on the AI Act, but you might already be aware that the discussion on how to regulate AI has been around for much longer. I think in 2016 already, the Parliament was discussing assigning legal personality to robots. We've steered away from that approach. We've also had the high-level expert group on AI that was working between 2018 and 2019 or 2020, I'm not entirely sure. There was an impact assessment, of course, of such an AI Act, and there was a white paper on AI in 2020. But AI Act, as we have it now, kind of started in 2021. It took the Council 1.5 years to adopt its common position on the AI Act. And as you can see, the Parliament took another half a year before they agreed on their common position. Now it's quite an unusual delay in the timeline here. And that, of course, has to do with ChatGPT. That was released in November 2022, but I think the real impact became clear around February, March. So the Parliament went back and revised a lot of their position in order to make sure that foundation models and general purpose AI are sufficiently covered by this regulation as well. Then we've had the trilogues, of course, that took place on December 9th. After 22 hours of negotiations, we have the provisional agreement. Now what is ongoing are the technical meetings, so closing of the final loopholes, and then on February 2nd, the formal vote on adoption of the AI Act is scheduled to take place at the ambassador level, so the co-rapper. That will be only a yes or no vote. The Belgian presidency is accepting no comments or reservation at this stage, as far as I know. But that's the timeline. Now, what is in it? As I've said, this is kind of the Commission proposal, or that is where all of this originated from. So, yeah, just as to keep in mind. So the whole motivation of the AI came from the realization that AI poses new challenges to fundamental rights, safety, and the effective functioning of the liability regimes. As Ika, I hope I definitely mispronounced your name, apologies, mentioned already, there is not a regulatory vacuum. Prior to the AI Act, we have different kind of directives and regulation in place. Of course, there's GDPR that already kind of deals with privacy and data protection, but AI poses new challenges that need to be covered in a different way. So that is how the AI Act came to be, with the main objectives of protecting fundamental rights and ensuring safety, and eliminating obstacles to trade. So this focus has to do with the legal basis of this regulation. You might notice that the functioning of the liability regimes is not covered by the AI Act, or is not an objective of the AI Act. And there have recently been agreed updates to the Product Liability Directive on 14th of December. I have not looked into that, but I wanted to flag that there are other places where the liability regimes are covered. There's also the AI Liability Directive, if I'm not mistaken. Sorry, I know I'm quite quickly moving through all of this. I think I really want to get to the most interesting parts. But of course, the general approach needs to be discussed as well. So I don't know, please flag to me if I'm moving too quickly. So on the general approach, I'm sure you're all aware, this is a regulation, not a directive. That means it is applicable across all member states equally, so to speak. The directive needs to be transposed and translated into national law, and that often leads to quite some divergence between how member states handle a certain directive in that case then. Second of all, the AI Act is a horizontal regulation and not sector specific. That means that sometimes we have specific sectors that have other regulation that is applicable. The medical devices is a key example here. And for those sectors, there's quite a high compliance cost or like a regulatory burden. Similar things apply to machinery that is regulated under the machinery regulation. But we also talk about AI being a universal technology. That means it can be applied to all sectors and affects all areas of life. So personally, I think a horizontal approach makes sense to mirror this universality of the technology itself. A third aspect of the general approach that was defined by the Commission and that we've maintained is that it is attempting to be technology neutral, and however far that is possible. But what this means for this AI Act in particular is that this regulation is not just regulating AI because it's AI, it is regulating those AI systems that pose new risks compared to other AI systems and compared to other technologies. And this already hints to the fourth aspect, the final one that I will touch upon, of the AI Act, and that is that it is a risk-based approach. So it is not regulating AI, it is regulating use cases and the risks that are associated with it. I'm sure that in the 3 years that we've been talking about the AI Act, you've also heard about the different levels of risk. So there are 4 levels of risks. According to the AI Act, we have use cases of minimal risk. Those can be used freely. You can think here of AI-enabled video games or spam filters. So there's really not much, depending on these, I would say. So these can be used freely, and the vast majority of AI systems currently used in the EU fall into this category. Then there is the level of risk of limited risk. There are some specific transparency obligations. I will talk in depth about the third level of risk, high-risk AI systems. These are permitted use cases, but subject to specific requirements, and for example, an ex-ante conformity assessment. But like I've said, I will talk about it in depth in 2 minutes. And finally, there is the category of unacceptable risk, which I think is quite impressive, that they did agree to have this category. That means use cases that are deemed unacceptably risky are prohibited in the EU. And I think in a context where not stifling innovation seems to be the main motivation, many times having this category is showing quite some backbone, I would say. Now the part that I will skip is the TRILAC positions, because that is outdated. And I come to the provisional agreement. By the way, this version that I looked at is the same version that was shared with EU countries on Sunday afternoon, ahead of a discussion within the Telecom Working Party, a technical body of the EU Council that will be meeting, meeting tomorrow. And already, as I've said in the very beginning, I looked at two questions. And I did not look at the full text. First of all, the question that I asked is, how is AI in workplace covered? And I hope that I won't have too much overlap with the following presentations. And then second of all, I will dive into the rules, obligations, requirements that apply to high-risk use cases. AI the workplace environments is mentioned two times very specifically, very explicitly. The first one is in Article 5, which lists the prohibited AI practices. And here it is defined that AI systems for emotion inference in workplace environments is prohibited. So as you can see here in the little screenshot of the text, AI systems sort of infer emotions of a natural person in the areas of workplace and education institutions is prohibited. And the second big place where it is mentioned is in Annex 3, which is the list of high-risk AI systems. And here AI system used for recruitment, evaluation of performance, decisions on promotion, termination of employment, or task allocations. These are deemed high-risk use cases. Now, this, of course, brings the big question on what are high-risk AI use cases in particular, what makes an AI system high risk, and what kind of requirements and obligations come with this categorization. A high-risk AI system overall is a system that poses significant risk of harm to the health, safety, or fundamental rights of natural persons, including by materially influencing the outcome of decision-making. Now, the question is, of course, how do we know that there is a risk to fundamental rights or the health and safety of natural persons? There are two cases where a high-risk category is assumed or applies. First of all, that is safety components of regulated products. These are subject to third-party assessments under their relevant sectorial legislation that applies, or what I'm more familiar with is the machinery regulation. In this case, it has recently been revised from the machinery directive to the machinery regulation to be able to cover the new risks that are posed by AI systems in machinery products. And second of all, high-risk AI systems are also certain standalone AI systems in the following fields. I also wanted to highlight here two things. First of all, you see in bold, employment and workers' management, access to self-employment is one of the fields in which AI systems are considered high risk, as I've mentioned at the very beginning of this section. And I also wanted to highlight here the importance of the annexes of the regulation. As you can see, or you can find this list of AI systems or fields in which an AI system is a high-risk use case in the Annex 3. And a lot of these lists in the annexes are in the annex because annexes are easier to change compared to the text of the regulation. So this is an attempt at future-proofing this regulation by making sure that we can quickly add a new field to the Annex 3 in order to account for the changes and developments in the field. Now, as a provider of a high-risk AI system in employment, for example, you might disagree and say that actually my AI system is not high risk. Then you must carry out an assessment before you place that system on the market. And this needs to be also recorded in one of the databases or registries. When I first came across this article, I was thinking, okay, that's actually quite the loophole here. Luckily, there's also Article 65 that deals with this and makes an attempt at closing this loophole by suggesting that once a market surveillance authority finds that the AI system concerned is actually a high risk and not high risk, it can require all necessary actions to bring the AI system into compliance. But from my reading of this, that means that there can be a little gap in which it is falsely classified, but we might hear more about that later. I also wanted to include that there is now a mention of fundamental rights impact assessment in the regulation. As far as I know, the Commission's proposal at least did not include this. Article 29A discusses fundamental rights impact assessment. And I'm throwing around all of these articles just in case that you would like to do some more research, and then you can already use the search function to find something in the text. Yes, and a fundamental rights impact assessment is part of the obligations of the deployer. The deployer was formerly called the user of an AI system, and it is the one that actually puts it to use within their own operations. Yes, and they shall perform an assessment of the impact on fundamental rights. Yes, and this fundamental rights impact assessment, and I'm also bringing this up to highlight another aspect of this regulation, shall be supported by the AI Office, one of the governance bodies of the AI Act. They shall develop a template for a questionnaire that should include many of the obligations of Article 29, but among them also this fundamental rights impact assessment. And I think this also, well, this is a great place in my eyes to emphasize the role that soft law will play in this regulation and implementing this regulation. For example, we have guidelines that the AI Office is supposed to develop, but also standards will play a massive role in defining how this will look in practice. Now, already talking for 17 minutes, so I will move on to the obligations for high-risk AI systems. By the way, I'm sorry, I realized that I'm also jumping a bit. Keep in mind, I've had 24 hours with the text and I tried to find the most important bits and pieces. But coming now for the obligations for high-risk AI systems, so this also applies for AI systems in the workplace, as I've mentioned them before. Providers of high-risk AI systems are the natural or legal person, public authority, agency, or the body that develops an AI system and places that system on the market. So just to be mindful of who this might be. Providers or developers of AI systems. They shall ensure compliance and have fixation of the CE marking, so they are dealing with that aspect. And they shall also set up a quality management system. This is, I think, interesting because standards will actually define what a quality management system looks like. We know already that it includes a risk management system. A risk management system includes identifying certain risks that are posed by the system and mitigation measures to that. But as I've said, I'm really curious to see the details as they will be decided in the standards. Deployers of high-risk AI systems, they were formerly called users, means any natural or legal person that is using an AI system under its authority, except if it is for non-professional activities, personal non-professional activities. Deployers of high-risk AI systems must assign human oversight to natural persons who have the necessary competence, training, and authority, as well as the necessary support. This human oversight dimension is new, as far as I know, and I wanted to flag this because I think it's important that it also comes with necessary training and support. Another obligation of the deployer is applicable when the deployers are also employers, because they must inform workers, representatives, and effective workers of putting in place such a system. As you can see, it is just an information obligation. There is no consultation that comes along with it. I'm really curious to hear more about from the other panelists what they have to say on this. There are also a whole bunch of documentation, information, and transparency requirements, but I wanted to flag another new aspect of this provision agreement, which is Chapter 3B on the remedies, because now finally the AI Act also includes a right to lodge a complaint and a right to explanation. In my perception, that's a major win from CSOs who have been pushing for this basically since the start. Final slide for me is on the implementation, on the timeline. The AI Act will come into force 20 days after publication in the official journal of the EU, and then will apply 24 months following the entering into force of this regulation, but there are a lot of exceptions. For example, the prohibitions already apply after 6 months, notifying authorities. governance, general purpose AI, and penalties apply after 12 months already. And the requirements obligations for high-risk AI system only after 36 months following the entry into force of this regulation. And this has been my speed run through the AI Act. I hope this was interesting, understandable, and I already see that there are some questions through the Q&A. So I will stop sharing. Thank you very much.
Thank you very much, Paula. That's a great overview, and I must say, like, quite a speed run, considering also that we are actually like talking about the moving target legislation that's currently being negotiated. So I must say, like, you summarized it very well, not only the process, but of course the content as well. We have had a couple of questions. I will come back to those in a bit. Some of them are a bit more mundane about the housekeeping and such. But I must say, like, just to reflect on this, that the negotiation process of the AI Act has been one of the rockier ones that I have at least had on the recent memory of the EU. And it partially, of course, shows like how sensitive the topic of regulating artificial intelligence is, but also in the same time, how much of a moving target it is. In the middle of the process, the parliament and the legislators, they had to take a step back when the foundation model sort of broke through into the massive use where they are at the moment. So this has caused, of course, like the delays on the process. Now we had a couple of questions. One about the presentation, which I think we will be able to share, as we are sharing anyway the webinar afterwards in a recording, so that won't be an issue. So just to clarify also, the actual regulation is not going to be 1,000 pages long. It will be more or less the regular size of a regulation, and it's only a negotiation file that we are having 1,000 pages long. We will have some presentation coming up on the examples of what actually these high-risk systems entail and what also are prohibited practices. And I think the next presentation from Kate will focus on that one. So I won't dive too much into this discussion just yet. But maybe one quick reflection, Paula, from my side. Even though we are talking about the regulation, which normally means that it will be applied in the EU, in all of the EU member states in a similar way. To my understanding, there is indeed an article here which specifies that the member states, they can also pick up a bit more ambitious approach in case needed. Is there much room to maneuver for the member states themselves to go further on regulating AI? And as you mentioned, of course, the EU itself, it's already preparing to have a possibility to amend the annexes, which is a lighter approach, and have delegated acts to do so.
So I'll be honest, I haven't looked too closely into that, to how much wiggle room the member states have to go beyond what is already existing. But of course, there's national laws already in place that might affect how AI is used in different sectors. So labor law, as I understand, is also national competency. So how that will interact with labor law, I think on national level will also again be quite difficult. And I don't think it's unheard of that member states choose to be stricter in enforcing regulation than other member states are. And yeah, as you've mentioned, the Commission can edit the annexes quite a bit, and then of course also have delegated acts. I also haven't touched on the governance structure of the AI Act. There will be an AI office under the Commission, but there also will be an AI board that, if I understand correctly, will have members of all member states and also consult with external experts. So I'm also curious to see what kind of discussions will happen in those governance bodies and how that will actually change over time as well.
Exactly. I think we are actually looking forward for sort of a creation of plenty of new forums for AI discussions. So this won't be the last webinar we will be having on the topic. But thank you very much, Paula, for the presentation again, and great to have this sort of overview. And from here on, I think we can move forward and look specifically towards the European workplaces angle. And of course, the world of work, it has seen a rapid increase of AI systems, which has ranged from anything used for the production models to service models and management of work, of course. There's plenty of HR applications which are dealing with sensitive worker data. And we are having Kate Munkriom from AC Denmark, who will provide us with a presentation, moving from the general aspects of the AI Act to showcase more that what are actually the impacts that the AI Act will have on the European workers. So without further ado, Kate, the floor is yours, and I will share the presentation.
Thanks a lot, Ilka, and thanks to everybody for joining us. Yes, I and my organization is a member of AEQUITAS and has been for many years. And before I start my presentation, I would like to come with a disclaimer, which is important to understand where we are, because actually this piece of legislation should be seen very much as a legislation concerning internal market, how to promote the internal market of AI at a European level. And the reason why I say this is now you are going to hear me say that we lack a perspective of workplaces and work as such in the piece of legislation, but actually that's not the purpose at all with this kind of legislation. So why is this not just a commodity? Why is AI just not a commodity like everything else? Well, it is not a commodity like everything else because this is, as Ilka put it, a moving target. AI is changing all the time. So actually, this is why we needed a special kind of regulation, some new way to handle this kind of difficulties we have. And when we say this is, or we just heard that this is a cross-sectoral approach in this piece of legislation, it's horizontal. Then we can also say it's what we call a de facto Brussels effect we will get on this kind of regulation. Meaning that, like we saw with the GDPR, this will pave the way for setting norms on this market. Of course, in many countries, both in China and Brazil and the States, you have actually sector regulation, but the cross-sector perspective or approach is new. And that is why what we are going to see here is quite historical. So this was just the disclaimer before starting, because what we are focusing on and what we are interested in as trade union is, of course, the workplace perspective. So what I will go through with you is trying to answer these three questions put to you here. How does the AI Act address European workplaces? Because there are some pieces we can use and which will help us. The second question is, what are the gaps? What are we missing? And the third one is, what in this kind of legislation or other kinds of tools can help us protect workers when it comes to AI? So these are the three questions addressing you here. So I'm not going to use a lot of time on this because you just heard it. Just remind you that we are talking about a risk approach, and which is very new, and also from our perspective, very welcomed, is the non-acceptable risk. There are areas where we simply cannot accept that AI will be used. And then there are the high-risk areas, and here we are slowly going into what I will call a labor and a workplace perspective. And when we're talking about the high-risk area, then you have certain demands. What should be put in place to secure that AI is used in a proper and acceptable way? And these are the demands we have for the conformity assessment when it comes to using AI in high-risk areas. And then I would also like to add, we should also remind ourselves there are a lot of areas where there are absolutely no risk and therefore no obligations. Sometimes when you read articles or debates in newspapers, it's like, oh, this is going to sort of be a big problem, this kind of regulation for every new development within AI. And that's certainly not the case, I would like to underline. So what is it actually that this AI Act is prohibiting? And these are just to remind you that there are still areas where we say AI is a no-go. And it's biometric categorization systems. This has been a lot debated in newspapers all over. When we have this categorization, it can jeopardize, and we also have the toxic case about biased when doing this categorization. So here in the Act, it states this should not be allowed. Then there's the untargeted scraping of facial images, also a ban on this. Same goes for emotional recognition, social scoring, manipulating human behavior, and exploiting vulnerable groups. So these are the areas where we say this is a no-go. And I agree with the previous speaker that this is actually a big victory, because it has been very much debated whether we should actually say no to these areas, or whether it could be accepted as high-risk areas. But here they are, the no-goes. So what is needed when it comes to the high-risk areas? And to high-risk areas, we put certain demands, and the high-risk areas are the areas you see here. It's infrastructure, it's education and vocational training, and now you see we are moving a little bit nearer to what we call workplace perspectives. Also, when it comes to safety components of products, you have robots used in many kind of industries today. Also, high risk area employment and management of workers. And here, of course, we are very much in the core of what I will call workplace perspectives and approaches. We have public and private services. We have law enforcement, migration, and administration. So these are the high-risk areas. And some of them are very, very important to us as trade unions, and especially the one you see underlined here. So what is in the Act on the workplace scope? I'll go quickly through this because you heard it from the previous speaker. We have the Annex 3 pointing out these two specific areas: the use for recruitment or selection of natural persons, and also the decisions on promoting and termination of work-related relationships. So these are the two areas specifically mentioned in Annex 3. And as we also heard, we don't know if other areas will be added in the future, but for now, this is what we see. So here you have what we call a limited scope on algorithmic management in this Annex 3. And can we go back, Ilka? Thank you. And what you see below is the reason why we have so little focus on the workplace and the employment perspective is that this is an internal market perspective. This is demands to companies developing AI, and the demands is in this what we call a life cycle. Demands to the development, to the use, to the analysis, and to the redesign of AI. So this is actually a focus on the project, not so much on the actual application. So if we go on to having a look on what's not in the Act, here's an overview from Berkeley University. where you have a lot of examples on what is not covered in the Act. And I would like to give you a few examples from workplaces we know on where AI is actually being used. We see right now in my country, Denmark, we are building what we call super hospitals. And in these super hospitals, all employees, and especially doctors and people working very close to patients, they will be provided with sensors. And these sensors, of course, collect data on where everybody is at a given hospital. Of course, this seems super good idea, because then you will know where everybody is, and you will limit and effective all the procedures, so the patient will get quicker treatment. At the same time, these kind of data can also be used to rewarding or punishing employees being non-effective. So just to give you an example, another example where we see AI used is in public administration. We had an example in Denmark in an agency responsible for helping unemployed to get a job. And they sort of experimented with AI and profiling and identifying unemployment with high risk of becoming long-term unemployed. This actually was over the top for our politicians, so they banned this kind of exercise, but actually there were no rules, no regulation prohibiting this kind of practice. And the example that many of us know from our daily work in administration, we also have the Microsoft Office package, where we collect, or they collect, a lot of data on us. This can be sure and find, and a good way to find out what kind of work we are doing, if we are using too much time on tasks we're not supposed to use a lot of time on. But on the other hand, we also sort of get the programs to tell us what's useful and what's not useful, because of course they are valued when they tell us you are having too many meetings or too long meetings. Who's defining that? Not me, not my boss, not my colleagues. It's the system, it's the AI defining these kind of values. So again, something which is very much in everyday's practice and work, but not actually regulated anywhere. So if we move on, what we have done in AEQUITAS is, while we are waiting for the regulation we would like to see, we have developed what we call a checklist on ethical use of AI. We have, as you see, 7 principles, and under each principle we have a number of questions that you should put yourself and your managers when using AI. And to put it very short, what we ask for is actually a dialogue at workplace level, an internal governance structure where you have a dialogue, employees and management, on how and where and why to use AI. And that was actually what we hoped to see in the AI Act, but what is not really there yet. So what we are aiming at, if you can put the last slide, Ilka, thanks a lot. What we are aiming at is actually having a look at the AI Act and looking for, now we put the word national implementation, and here I would like to add, there's not really much to discuss on the national level, because when we are talking about an act, it's not like a directive that you have room for maneuver. You have to translate it word by word into national regulation. What you can do, however, is to add something in top of that or beside the act, but the act as such cannot be debated. That's why, since we don't think the act is covering what we would like to see concerning the workplace level, we are now pleading for a directive on algorithmic management. There's actually some of this in the platform directive. There you have a special chapter on algorithmic management. But since the platform directive is not yet adopted or agreed upon, it's important for us to sort of still have a focus on this. But again, while we are waiting for a better world, we have to also work on what we can do at company level, at sector level. And in many companies and sectors, you have collective agreements. And what I can give you an example, what we are trying to do in my country right now, we are in the middle of collective negotiations in the public sector. And here, one of our demands in these negotiations is actually to go through all our regulation and see whether we have the right regulation to address the new questions concerning the use of AI. And if this mapping shows that we don't have the regulation covering this, we will ask for new regulation. And another thing we have done is we have used the checklist that AEQUITAS has developed to train our shop stewards and make them put these questions at workplace levels. So there will be a dialogue between managers and employees on how, when, and where to use AI. So this is, for us at least, a very important tool to pave the way for national regulation, soft or hard law. As you can see here, we're trying both ways in order to cover what is not covered by the AI Act. I think this is what I have to tell you right now, but please ask questions if you have some. Thank you.
Thank you very much, Kate. I must say that we have been having quite a lively discussion also on the Q&A section in the meanwhile. So please refer to answers that Paula has given there for a couple of the key questions. Also, gentle reminder that the Q&A section that's used for questions only and less for the comments. It's simply to keep it a bit cleaner. So if you can focus on asking the questions from the presenters, that would be great. I must say, Kate, that very good presentation with clear examples why this thing it's actually happening now very much so. That the AI Act, it has potential to be as sort of an important piece of protecting fundamental rights as GDPR has been. But at the moment, as we could see, I think it was your 5th slide, that a lot of the aspects that the artificial intelligence systems are using at the moment, they are not properly covered by the AI Act. And the issue here is that anything that you saw on the larger slide from the list of features ranging from biometric recognition, like these capabilities, they do exist already. These applications, they do exist. They are mostly used in markets like in the US, where you have a bit, I hate to use the word dystopian when talking about technical experiments, but the Amazon wristbands, for example, tracking down workers' toilet behavior and these sort of issues, they seem very unworldly for us in the European perspective. Now, sort of a quick also note, we of course mentioned that there's quite a lot of banned practices, and I don't want to open another can of worms on this, but for example, the facial recognition, of course, there's a national security exemption for that one, and which is another civil rights aspect, and this is being negotiated and a topic of quite a lot of debate at the moment. So we are not going to focus on that one simply because it's not that much of a workplace dimension. But I'd like to maybe ask just one clarifying question, Kate, about the collective bargaining side of things. So this is actually showing the power of trade unions in a lot of ways, that on this sort of a situation where we have new legislation coming up and we have also clear gaps that are already on the new legislation. How can trade unions be active? Is it not only on the collective agreements on sectoral level, but also on company level? And would you also consider that this is actually a way how to showcase where the legislation has to go? Like, what are these sort of great angles that we have to take into account when protecting the workers from adverse impacts of the artificial intelligence?
Well, what we are hoping for, at least, is that we, together with the employers, can agree on what's already covered and what are we missing in our regulation. And that is why we have put it into collective bargaining this year, is to actually try and find an alliance with employers. Because if we can agree on this, then we can go to the parliament and say, please help us. Or if we find out we actually have a few agreements where we could put some new text, this could also be a way to sort of enforce and make better what already exists. Because of course we should not invent something if we already have some tools that we should just try and adjust a little bit to a new reality. Then that will be the way to go. And when it comes to company level, even if we do what I just suggested, I think we still need to train both managers and employees on how to have a dialogue on this. Because, to be quite honest, otherwise it will be colorblind talking about the colors. We actually don't really know what kind of questions we should ask one another, and we don't actually also have to agree on, we cannot once a year, for instance, make an agreement on this, because as we heard, it's a moving target. So we have to, I mean, at least 4 times a year or something like that, try and sit down and talk to each other about this issue. And if we agree on, well, nothing has changed since we met last time, then fine. But at least we have a dialogue, a place where we can address our concerns and have a common understanding on what's needed and what's not. Because what we also see when we talk about AI is that we can collect a lot of data, and but are we? Is it necessary? Is it necessary
Exactly.
for us to have all these kind of data when we actually have been living quite happily without it, to be quite frank?
Yeah, I think we are now closing in exactly on the technical application, and which is smoothly taking us to the next presentation. So thank you very much, Kate, for your insights on this one. And I know that Maria from Ally is having a bit of a tight schedule, so we will start with your presentation without further ado. And especially talking about the technical applications, the AEQUITAS project, which is Commission funded, is specifically focusing on having giving tools for the workers, but also for other civil society actors to disseminate and look into the unethical and untrustworthy AI practices, because as we do know, untrustworthy AI, it's going to be a lose-lose for pretty much all the participants involved. So Maria, I know that you have a tight schedule, so I will give you the floor without further shenanigans from my side.
Thank you very much. Just give me 1 second to share my screen. Oh. Okay. Do you see it? Do you see my presentation?
Yes.
Yes.
It's visible.
Okay, thank you. Thank you very much for the introduction, and thank you for having me today. I look forward to all your questions once this presentation is finished from the participants. So welcome. Today I will be talking about AI fairness and the tool that we are creating to ensure or test whether an AI system is fair. A little bit about myself and my workplace. My name is Maria, and I have a background in social legal sciences, and I have joined the Ally team quite some time ago, and now my focus is on the project that I will be talking about. Ally is an independent organization who was created by Katelein Müller, who is an expert in AI. She was part of the OECD as well as the high-level expert group. Our mission at Ally is simply to make sure that AI is used responsibly, that applications are trustworthy, and that the laws that we create really protect our fundamental rights. To support that mission, we have joined the project called AEQUITAS. And today I will be talking about what AI fairness is, how we can achieve AI fairness, and a particular look at the AI Act and how fairness can be seen within the regulation proposal. And then I will be quickly discussing the AEQUITAS tool and how all of these different fairness aspects fit within our AEQUITAS project. So let's begin. What is AI fairness? Within our project, we launched a stakeholder-based survey in which we asked different groups to explain to us, what do you think AI fairness is? And at that point, we had responses from all these different interdisciplinary fields, more technical answers, more legal answers, ethical answers that were based more on social sciences. And at the end, a short list of the descriptions that we received on AI fairness looked a bit like this. You can see there are many, many words, and that AI fairness was defined rather broadly. We have terms such as compliance or statistical parity. We talk about equality or equity. All of these different areas or aspects need to be considered when we talk about AI fairness. We categorized these answers and we came up with 4 different dimensions in which we see AI fairness being reflected. And that is the social dimension, the ethical dimension, the legal, and the technical. In the social dimension, we see factors such as equality and equity. We see that it is about creating or using AI that helps ensure these equality of opportunity in society, that helps ensure non-discrimination. That will be AI that is fair from a social perspective. From an ethical perspective, we start talking about digital ethical principles that apply to AI fairness. This includes human agency and oversight, technical robustness and safety, privacy and data governance. If you recall the presentation that was just before me, you've seen some of these ethical principles reflected in that list. Now, an AI that is fair is an AI that would naturally respect those ethical principles. On the legal dimension, that is where we talk about fundamental rights. That is where we look at international regulations, compliance, accountability, all these different factors that we have heard of in passing today. As was said, AI doesn't really operate in a legal vacuum. So in order to have fair AI, we need to be legally compliant. Finally, what we understand under the technical dimension of AI fairness is statistical parity. Having a representative data set, ensuring that our system is fair by design and that it is explainable. So from all these different perspectives, we can now trace a context in which we can assess AI fairness and unfairness. An unfair AI system is one that does not respect one of the categories that was listed there, or one of the sub-components of these categories. By understanding really what AI fairness is, we determine the context and the way in which we want AI systems to be built, and what we truly understand within trustworthy or responsible AI system when we use those broader discursive terms. Finally, if we understand what AI fairness is, we can, of course, understand what AI unfairness is. So that will be the kind of risks that are being now at play when AI system is being employed. So now that we have an overview of what AI fairness could be, the different dimensions, it is important to ask ourselves, how do we truly achieve fair AI? And looking at all these different dimensions, we see that we have different tools. On the social dimensions, we hear about participatory design or identification of risk and harm. Those are tools that are used in order to truly assess the effect of a certain AI system in different society groups. So making sure that every societal group is represented, that all identities are being considered when the AI system is developed or when its effect on society is being assessed. On the ethical dimensions, we have several frameworks, including the European Guidelines for Trustworthy AI, including the OECD AI principles or the UNESCO recommendations. At the same time, we see the operationalization of these frameworks within different projects. So, for example, the ALTAI, the Assessment List for Trustworthy AI, provides us a more in-depth look on how we can truly understand and read ethical principles that support the fair interpretation, the fair application, of AI systems. Similarly, ethics impact assessments, now we heard a lot about impact assessments, are a way to consider whether our artificial intelligence system is being ethically applied and falls in line with the ethical principles that are listed in the frameworks that I just mentioned. Now, when it comes for tools for the legal dimension, of course, we have the laws. Again, AI doesn't operate in a legal vacuum, but we also can use courts, we can use adjudication fora in order to actually apply and make sure that those laws do hold the right players accountable. So it's not only just a law, but it is also the fora that, help implement and ensure that the law is being implemented. Of course, finally, we have the tools which stem from the technical dimension, and those are not only referring to technical standards, but also practical tools such as applications or websites that can be used to assess your AI system. And one of these proposed tools is AEQUITAS, which we will hear of in about 5 minutes. But before we move forward, I want to take a look at the legal fairness dimension, and that is the AI Act. Now, we heard a lot about how the AI Act is applied, and the most important thing to know in relation to AI fairness is, of course, does it even apply, and whether the system is classified within the AI Act and in which category. Now, when it comes to workplace and employment, I won't dwell too much on this because we've heard in the previous presentations. We know that emotional recognition systems within the workplace are prohibited, and AI systems that are intended for recruitment or selection of natural persons, as well as those that make decisions on promotion or termination of work-related contractual relationships, are considered as high risk. Now, exactly as we heard before, high risk implies that there are stricter requirements that a developer or a user must adhere to in order to, make their system legally compliant. These requirements are listed here, just the headlines. But what I want you to take away from this is that every single one of these requirements speaks to different dimensions of fairness. For example, when we look at data and data governance, the article itself talks about different forms of data governance. Namely, we need to look at whether the data sets are correctly split, whether the data is free of errors. But it also includes requirements such as the data must be bias-free or have as little bias as possible. And those requirements, each respectively, kind of demonstrate or speak to a different area of fairness. So when we talk about checking whether your data sets are correctly split, then we talk about the technical dimension of fairness. It is a way in which the technical fairness is reflected within the law. At the same time, when we talk about bias-free or error-free, or representative, which is also a requirement, we see that we are asking a more social requirement. It's more speaking to the social dimension of AI fairness. The idea is that within the legal dimension and within the AI Act, we try to observe how all these different fairness forms interplay with each other. And most importantly, the law itself is trying to put forward a mechanism in which we can assure fairness and in which we can assure that fundamental rights are protected. Now, within the AEQUITAS project, which is coming up next, we are trying to find a way to not only interpret the law from these different fairness perspectives, like I've just done, but also put them in a practical application. So the AEQUITAS project is a 3-year project funded by the European Union, and our goal is to understand AI fairness and diagnose and repair unfair AI systems. We create this experimentation environment that serves the diagnosis and repair of AI systems and provides different methodologies or different ways through which we can ensure that an AI system is made fair already from the design stages. The result of this 3-year project will be the AEQUITAS tool. This will be a online digital tool that will be available that on the basis of legal notions of fairness, social notions of fairness, ethical and technical dimensions, will be putting forward an assessment of an AI systems. It will be a service that is integrated onto platforms that you can then use to test the AI system that you are implementing for its fairness from all the different dimensions. And finally, within this tool, there will be different sets of awareness strategies that can be used to raise awareness of what AI fairness and unfairness can be, much like we've seen today, and truly appeal to workers and employers in order to be able to understand whether a new system that perhaps may not be covered by the AI Act is nevertheless a fair system. I hope that made sense to you. And if there are any questions, I would be very happy to answer them. But you may also reach out to one of the consortium members, the AEQUITAS consortium members that you see listed here. So Eurocadres is one of them, and Ally is one of them as well. So you may also contact me, shall you have any further questions, or shall you want to be keep updated on the AEQUITAS development, on the tool's launch, or on any of the methodologies and awareness tools that we are publishing along the way. Thank you very much for your attention. And of course, now I welcome any questions on your end.
Thank you very much, Maria. Now, before we jump to the questions, could we have also all the presenters, so Kate and Paula as well, to put your webcams on, just so we will get a bit of a, how would I put it, like a screenshot for the social media purposes for the future. And in the meanwhile, while we are having the webcams on, I think we had one question which was specifically for Kate. I know that Maria, you are having the tight schedule, so if there's anything coming up, I can also relay it afterwards. But Kate, there was a question specifically focusing on the super hospital case study from Denmark. So would you like to take that while we are at it?
I just wrote an answer, but I would like to tell you about it. Actually, the whole story about the super hospitals is actually that we try to involve all professions working in hospitals with engineers, architects, and the management to sort of find the best way to create a new hospitals being effective and delivering a higher level of service to patients. So that is actually what's being done. So it's a huge dialogue with the professions involved. And from what I hear is that it's working quite well, because they are asking them, these kind of professions, before constructing it and not after. So they are sort of part of the designing. So I'm not so worried about that case, but of course we have to keep a close eye on how this will evolve year by year, that it will not sort of go in the wrong direction, detecting how many times you have been to the toilet or how long you have used the lunch break, things like that. So of course it's not, you know, one time we do this dialogue and then it's fixed. No, we have to do it, you know, continuously to make it work.
Exactly. Artificial intelligence, after all, it is there's a lot of mystification going on at the moment, and people are not fully grasping it. But at the end of the day, it's a tool as in any other, and a lot of the questions we have had actually, like since the beginning of formal capitalistic working relationships, like they are still very much the same as we are. I don't have any further questions at the moment, but of course, well, I trust on the attendees that you have the capacity to also get in touch with our speakers afterwards. And firstly, without going to the more general, thanks you. Firstly, thanks a lot, Maria, for the presentation on Equitas and also the trustworthiness of the AI systems in general. I must say that from the trade union perspective and civil society perspective in particular, these sort of tools that these projects are providing are so crucial on disseminating the systems and also providing more ways of actually tailoring the legislation in a way that it's ethical and it's really safeguarding the fundamental rights in workplaces and beyond. And this is specifically the sort of a project actually where for our attendees and participants of the seminar, we would very much welcome if you have case studies, if you have feedback or some sort of questions that you would like to bring to us. You will have, of course, the Euroc address contact details. I will put them in the chat, or but I think one of my colleagues can put also an email address to the chat, because as part of the Equitas project, we are specifically looking on real life cases where there has been unethical AI use, or there has been otherwise some discussions where the trade unions have been active. So please do not hesitate to get in touch with us. I would be more than happy to also like continue those conversations after the webinar. And in case somebody also like checks out this webinar afterwards in a recording, you are feel free to get in touch with us. The project keeps on going for nearly 2 years more. So you will have kind of a long window to actually get these tools really into use and see what they can do to better the fundamental rights angle in workplaces and beyond. And finally, I would say that this has been very enlightening conversation, even for somebody who has been following the AI Act and this conversation for a long time. So thank you very much for our presenters, Maria, Paula, and of course, Kate, for your presentations. I think we covered very well the different angles ranging from the legislation that's coming up to the workplace level, and of course to those hard tools and ethical questions that are coming down on application to application basis. And as today has shown, we are not really on the verge of the AI revolution, but we are actually in the very middle of it. The AI shapes our workplaces on this very moment, and this work that we are doing not only on regulation but also on the workplace level, it is the one which is defining how AI will impact the way how we work and how the work life will look in the future. So this is why the robust regulation is so much needed, and that's why we also need to have enough capacity and know how to scrutinize these systems. And yeah, I think we are also out of our time for today's webinar. Thanks a lot for the participation rate, and feel free to also like get in touch with us afterwards. Once more, thank you for the presenters. This was Euroc Addresses webinar on artificial intelligence and EU workplaces. My name is Ilkka Penttinen-Foutu, and I for one welcome our new AI overlords. Thank you very much and have a nice day.